When the Appellate Division conducts a weight of the evidence analysis, do they have to explicitly use the circumstantial evidence charge in a purely circumstantial evidence case? To find out, you have to read People versus Baque, but it's 25 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Baque. The citation for this case is 2024 New York Slip Opinion 05244, published by the New York Court of Appeals on October 24th of 2024. The issue in this case is whether the Appellate Division, in conducting a weight of the analysis examination of a conviction on a purely circumstantial case, has to explicitly say that it's applying the circumstantial evidence charge. To understand and appreciate the context of this case, the helpful background to know is that to be convicted of any offense, even in a circumstantial evidence case or not, a direct evidence case, guilt must be established beyond a reasonable doubt. But the circumstantial evidence case is a little different. Circumstantial evidence cases, when it's purely circumstantial evidence, there are facts that have to be established, and the only reasonable inference allowed, if you're going to return a conviction, is the inference of guilt. Basically, the test is that the inference of guilt is the only one that can fairly and reasonably be drawn from those facts, and that the evidence excludes, beyond a reasonable doubt, every reasonable hypothesis of innocence. So that's the circumstantial evidence analysis. And the other thing you have to know is that the Appellate Division has a special power under CPL 470.15. The Appellate Division, which is the intermediate appellate court, there's the trial court, the Appellate Division, and then the Court of Appeals, which is the highest court. The Appellate Division has a special power to conduct weight of the evidence analysis. They basically get to serve as what's considered like a super jury. Like if the jury convicts the defendant based upon certain evidence, the Appellate Division can be asked to conduct an analysis as to whether the conviction is against the weight of the evidence. They get to basically put themselves in the shoes of a jury, accepting the jury's conclusions on credibility, and then can conduct a weight of the evidence analysis. Okay, that's the background. What are the facts in this case? The facts are that the defendant in this case, Jorge Baque, had a 5-month-old daughter who was found unresponsive in her crib at 6:30 a.m. on July 30th, 2016. Despite efforts to resuscitate the baby, she was declared dead. An autopsy indicated that there was evidence that the baby had been shaken. But no one had seen this. There was no direct evidence showing, there was no testimony that anyone saw the defendant shake the baby, but the defendant was the last person with the baby alive, and the defendant was dead, and the evidence from the autopsy indicates that someone shook the baby. So the defendant was arrested and charged with manslaughter in the second degree for a shaken baby case and endangering the welfare of a child. And the defendant was convicted in the course of that trial. It was a purely circumstantial evidence kind of case. And so the jury was given the circumstantial evidence charge. The defendant was convicted of criminally negligent homicide and endangering the welfare of a child. The defendant appealed and asked the Appellate Division to conduct a weight of the evidence analysis, saying, my conviction is against the weight of the evidence under CPL 470.15. The Appellate Division conducted a review of the case and held that it was not against the weight of the evidence, but the way that they wrote it said that it was reasonable. They used the word reasonable. They said, because she lost consciousness and died after the defendant cared for her, it was reasonable for the jury to conclude beyond a reasonable doubt that the defendant violently and forcefully shook her, causing her death. That's how the Appellate Division analyzed the weight of the evidence issue, and it was then appealed to the Court of Appeals. And the complaint here is that the Appellate Division applied the wrong standard. They did not, according to the defendant, they did not apply that circumstantial evidence charge. They didn't describe in their analysis that they excluded all non-guilt inferences, all non-guilty hypotheses, and the only remaining hypothesis was of guilt. So the question here is, does the Appellate Division have to explicitly say, first of all, two questions. Does the Appellate Division have to apply that circumstantial evidence charge to themselves when conducting weight of the evidence analysis? And if they do they have to explicitly say that they did it? Do they have to use the magic words about the circumstantial evidence charge from that jury charge? And the answer from the Court of Appeals, the holding is, because the opinion doesn't say that they used the wrong standard, they didn't. The Appellate Division's analysis is affirmed But they do make a point of saying that they do have to basically apply that same circumstantial evidence, excluding all non-guilt hypotheses, to arrive at the guilty hypothesis. So in some, they say, we confirm that the same tenets the jury applies in a purely circumstantial case have to also apply to the appellate division in the weight of the evidence review. But there's nothing in the particular decision that says that they didn't apply that, so they're not going to reverse the appellate division's decision, and that's the case of People versus Baque. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.